Welcome to Resolutions, the official podcast of the American Bar Association section of dispute resolution. Every episode is a journey into the heart of conflict resolution, guided by our diverse community of experts. We're here to explore innovative strategies, share wisdom from the field, and inspire excellence in resolving disputes. Whether you're a dispute resolution professional, a curious learner, or someone passionate about fostering understanding and peace, you're in the right place. Let's dive into today's conversation and discover how we can transform conflict into opportunity together.
Hello, everyone, and welcome. Today, we're sitting down with Timothy Pierce. He is the Ethics Counsel for the State Bar of Wisconsin. He received his undergraduate and law degrees from the University of Wisconsin, where he teaches a course on professional responsibility. Tim was previously a deputy director at the Office of Lawyer Regulation. He has also been employed as the ethics administrator for Milbank in New York and as an assistant state public defender in Racine, Wisconsin. He is a member of the State Bar of Wisconsin and a frequent speaker on matters of professional conduct. As a note, he does not serve as a third-party neutral, but advises on lawyer best practices per the rules of professional conduct. And so let me just remind everyone, we are here today to talk about ABA Ethics Opinion 518 that was issued on October 15th, 2025. As a general course, it's titled, A Lawyer's Duties to Avoid Misleading Communications When Acting as a Third-Party Neutral Mediator, and has 3 points of guidance for lawyer mediators. The duty under the ABA Model Rules of Professional Conduct 2.4 to explain their role to underrepresented parties, the duty to avoid statements that imply the lawyer mediator is seeking to achieve a party's best interests, and the duty to avoid dishonest, fraud, deceit, and misrepresentation when communicating with parties. With that, we're just going to sit down and understand more about the evolution of this opinion and Tim's role in that. Tim, welcome to the stage. Thanks so much for joining us.
Well, thanks for inviting me, Rekha.
So let's get into it. What was the lead up to this opinion and its drafting history, if you can share?
Sure. So as probably most, or at least some of your listeners will be aware, the ABA Standing Committee on Ethics issues opinions that provide non-binding guidance on how to comply with the ABA Model Rules of Professional Conduct. And most states, in fact, all 50 states now, base their model rule, their actual enforceable disciplinary rules on the ABA model rules. So the ABA ethics opinions are generally considered to be influential, if not binding, in jurisdictions. And one of our current members of the committee had a particular interest in whether or not we had something to say about lawyers acting as mediators, and a particular interest in what the lawyer's role as a mediator, how that sort of interacts with some of the accepted conventions in negotiations that lawyers can sometimes engage in, puffery, sort of exaggeration of clients' settlement positions or the way a case was valued in order to gain an advantage in the negotiation. So with that, the member of the committee expressed an interest in that, and the committee voted to proceed with an opinion, and off we went.
Marvelous. Thank you. And so the drafting process next is what we're interested in. Can you describe your role on that drafting committee, perhaps, backgrounds of the drafting committee members, just to understand how we compose of that committee and taking it forward?
Sure. The committee actually has, I believe, 12 officially appointed members right now, and the variety, there's a couple of professors who teach professional responsibility at law school. There's several practicing lawyers. Most of them concentrate in practicing professional responsibility law. My own background is I'm ethics counsel for a state bar, and I've taught PR for, I think this is about my 15th year at a law school. So generally, everybody on the committee has pretty substantial experience in professional responsibility law. There's also several people who participate as special advisors or liaisons from other ABA groups who also participate in the committee's work. And generally, what happens when an opinion is proposed, the committee will make a decision at a committee meeting whether or not to proceed with working on an opinion. And if the decision is yes, then one or more committee members who volunteer to do the actual drafting will get to work, and a draft will be presented at whatever committee meeting it's ready for. And the committee will then go through a process which usually lasts for several meetings. The committee meets once a month all year, so we have 12 meetings a year. And it's rare, at least in my experience of being on the committee for a couple of years now, for an opinion to be ready before it's been through 3 or 4 cycles. And that involves not just input and debate at the actual committee meetings, but also folks chiming in on revised drafts by email in between meetings. So that's kind of a long-winded way of saying we do put in quite a lot of work, at least we perceive it to be quite a lot of work, intensely revised. Every opinion receives many sets of eyes, and we really try to do as good and a thorough job as we possibly can with these.
Sure. Undergoing a process of revision is always a tremendous process with many voices. So we understand that. One of the questions also is that this opinion, like many that the ABA issues, right, persuasive authority, has to speak to all of the states, right, within the US, and there can be great variance of that. So how did you sort of come out to a neutral stance, thoughtful of these deviations state by state? And then, two-part question, if you could highlight for us from your own background coming from Wisconsin, what are the practices there, and how we move forward?
Sure. So I would say a couple things with respect to that. First, as no doubt you and most of your audience are aware, at least with respect to our mediation, while many mediators are lawyers, not necessarily all are lawyers. And when somebody is acting in a third-party neutral role, by definition, they are not acting in a representational capacity, which means what? That for non-lawyer mediators, the disciplinary rules for lawyers just don't apply because they're not lawyers. But even for those mediators who are lawyers, many of the disciplinary rules are client specific, meaning, for example, in representing a client, you have a duty of competence. In representing a client, you have a duty of confidentiality. All of the conflicts rules, for example, under the ABA model rules, are client specific. They have to do with representation of clients. In fact, only 2 of the ABA model rules are directly applicable to lawyers serving as third-party neutrals. That's Rule 2.4, which is the lawyer's third-party neutral rule, and 8.4, which is the general misconduct rule. That said, different jurisdictions may have or may not have either persuasive or mandatory rules based in court rules or statutes, sometimes in decisional law, that govern the conduct of people acting as third-party neutrals. So one of the things the ABA committee does, or the primary thing, is to provide guidance to lawyers in complying with the disciplinary rules for lawyers, and in certain opinions, the ABA model judicial code. So for judges. So given that, our remit was fairly narrow, right? We could talk about how, for example, rules 2.4 and 8.4 apply to lawyers acting as third-party neutrals, but because we can't offer 50 state-specific guidance, the best you can do is to advise lawyers, hey, if you do act as a third-party neutral in your specific jurisdiction, you should look to the laws of your own jurisdiction to determine if there's anything outside of the actual binding disciplinary rules that for lawyers that you need to look to in the jurisdiction. That said, as I alluded to earlier, most, in fact, all jurisdictions model their actual enforceable disciplinary rules on the ABA model rules. And to my knowledge, either all of them or the vast majority of them adhere at least to the basic concepts set forth in ABA Model Rule 2.4, right? With idea more of a statement than a requirement, that you're not acting in a representational capacity, and that under subsection B of that rule, the lawyer has an obligation to clarify their role, particularly when the participants to the dispute resolution process are unrepresented and do not have the benefit of receiving their own legal advice with respect to the process. So what we really focus on is, hey, lawyers, we can help you understand how we think Rule 2.4 and to a lesser extent 8.4 is best interpreted in your role as a third-party neutral. But also, you should be aware there may be other law that affects you. And as an example of that, as you stated, in my own jurisdiction, our court a few years ago undertook a process of revisions to various disciplinary rules and statutes designed to encourage lawyers to provide limited scope representation, and also makes, with the idea being to make more services easily accessible to lower income consumers of legal services. And one of those revisions was to our Wisconsin version of Rule 2.4, which is identical to ABA Model Rule 2.4 in subsections A and B, but then we have a specific subsection C in Wisconsin, which lays out a procedure whereby a lawyer can assist people in family dissolution cases, only divorce cases, in mediating the divorce and not act in any representational capacity. But it does allow lawyers, to draft documents that sort of give legal effect to any settlement reached in mediation. In Wisconsin, those would be a marital settlement agreement and other documents that we then permit the lawyer mediator, who again does not have a lawyer-client relationship, to draft with a court, to file rather with the court to sort of commence the process and allow the parties to then go to court without the lawyer to get the court to approve their divorce based on the resolution reached in mediation. So that would be an example of, hey, I've got ABA Model Rule 2.4, and that's ensconced in our Wisconsin disciplinary rules. But then I also have some other authority to look to. What we don't have in Wisconsin, and what many lawyers who act as mediators don't have in their jurisdiction, is rules that govern them specifically in acting as a mediator. So a few minutes ago, I talked about like the duty of competence under the disciplinary rules as being client specific. Well, because we don't have any quote unquote mediator rules in Wisconsin, you can't point to here's what gives legal effect for a mediator to conduct the mediation competently, right? We don't have the equivalent of disciplinary rules for mediators. Some jurisdictions do. And again, there are model codes for mediators. For example, the ABA model rules for mediators. But in Wisconsin, we're like some other jurisdictions where we don't have those. So our lawyer mediators are primarily acting off of the specific black letter requirement in our version of Rule 2.4, and then looking to other persuasive sources of guidance. And that's the case in many jurisdictions.
You raise a good example. We must all consult our local guidelines because there will be deviations and they get updated at different moments in time to just be sure we're operating under best practices. Thoughtful that we have deviation state to state, whether lawyer or non-lawyer, to be involved in the mediation process as neutral mediator. So let's approach this as for some of our listeners, they may never have read this opinion yet. This is the first time they're hearing about it. And opinions like this one often are drawing delicate lines between acceptable and prohibited practice. Can you flag or highlight for our listeners what are some key takeaways that they should be aware of with the issuance of this opinion?
Well, the primary obligation as set forth in the disciplinary rules for lawyers when acting as a third-party neutral is to be clear about the role. And if you look at ABA Model Rule 2.4, you have two subsections. A, which primarily states, look, when you're acting as a third-party neutral, you don't have a lawyer-client relationship with any of the parties to the dispute resolution process. And therefore, you are not acting in a representational capacity or an advocacy capacity, but rather acting as a third-party neutral. And then most important, I think in my view, more importantly for lawyers, is to make sure that you engage in reasonable efforts to ensure that the parties to the mediation understand what that means. And that's particularly important when they don't have the benefit of their own legal counsel. That is to say, they're unrepresented in the dispute resolution process. So you have an affirmative or lawyers rather have an affirmative obligation under sub B to explain that they don't have a lawyer-client relationship, and when necessary, when they have a reasonable basis to believe that a person does not understand what that means, to explain. And that's primarily two things as sort of discussed in the opinion. Number one, that you are not advocating for their best interest, meaning I'm not trying to achieve the best result for you. I'm trying to help you resolve this dispute. So I'm not giving you advice as to how to put yourself in the best position, but how to help you achieve a lawful resolution of whatever dispute you have. And explaining to people when necessary. And I think it's best practice if a lawyer is conducting a mediation and either or both of the parties to it are unrepresented, to really explain, look, I am not your lawyer. I'm not going to give you legal advice. You don't enjoy the traditional protections of a lawyer-client relationship, meaning you don't have a lawyer-client privilege with me. Some, unrepresented folks think, well, whatever I tell a lawyer is confidential, and whatever confidentiality protections might adhere to a specific alternative dispute resolution process is governed by law outside of the rules of professional conduct for lawyers. So the mediator should be aware of whether or not any of those apply, but certainly no lawyer-client privilege attaches to those. So really what we do in the first half of the opinion is just sort of explain what 2.4 really means. Make sure that you are clear with whoever is participating in it about your role, and if necessary, expound upon that so they have an understanding of what your role is. Now, On the other hand, if they're sophisticated parties, both sides are represented, they very well understand exactly what your role is because they've, been through it multiple times before and they have lawyers to advise them. But for example, to use my example of what we did in Wisconsin with our subsection C to our version of Rule 2.4, the vast majority of lawyers who undertake those sorts of family law mediations are dealing with individuals who are not represented in the process. So at least in our specific rule, we went so far as to outline exactly what a lawyer has to tell them at the beginning of the mediation to make sure that they understand exactly what the mediator's role is in the process.
Thank you. That's really helpful. I want to flag for our audience, there is a mediator checklist at the end of the rules, a useful tool to just go through to make sure you are following the rules, so to speak. Well, Tim, I'm going to end on a final question, and it's outside the purview of the opinion, but really, as ethics counsel, is there some common trends that you're seeing in inquiries you receive at present?
Well, I would say, you know, there's um, two things that are going on, both closely related. One might say they're one thing, is in, I think, many jurisdictions, many states, not just Wisconsin, we have a fair number of lawyers in our relatively bigger cities. In Wisconsin, that's Milwaukee and Madison. But rural areas of our state, we have a real problem with lack of lawyers. Some of our counties have single digits. For a while, in one county, there was no lawyer whatsoever who had an office in the county. And the expense, right? I see a lot of mediation practice in family law cases, and a contested divorce hearing can be extremely expensive for people of moderate or even middle income. So, one of the things that I think court systems and the organized bar in general is looking to sort of ameliorate this problem of lack of access to lawyers, legal resources, is to look at ways that alternative dispute resolution might help to sort of bridge that access to justice gap that we see, particularly in rural areas. And I can say from personal experience, that was 100% the animating force for us to adopt our mediator drafting rule in Wisconsin, which over the last 6 or 7 years has been quite successful. I would also note, sort of on the other, perhaps socioeconomic spectrum of alternative dispute resolution universe, I hear from my friends and colleagues who work in larger law firms and engage in, commercial litigation, that litigation being as expensive as it is, there certainly is, they, at least I think there's some perception of an uptick in arbitration of commercial disputes. So if I look at my legal career, I see a lot more alternative dispute resolution today than I did when I got out of law school 35 years ago. And one of the things that has been sort of part of my work as a lawyer who gives advice to other lawyers and is involved in the rules drafting and revision process in my own jurisdiction is to look to and see how we can accommodate what we see as this trend in the practice of law today. And I think that was part of the sort of impetus behind the ABA Ethics Committee wanting to issue Formal 18. We thought, well, let's see what we can say to at least contribute to the universe of guidance that's available to lawyers who act as third-party neutrals and at least knock off our little corner of how the disciplinary rules for lawyers speak to that role that a lawyer might perform.
Sure. I am curious as we uh, move to the future and AI, if there will be an ethics opinion that talks about the AI third-party neutral or the
Well,
AI arbitrator, which has been introduced already, and in no way, um,
yeah.
in no way am I saying that opinion is not already in the mix. But Tim, we may come back to you to have a
Okay.
chat on parameters and best practices as the landscape is evolving. And you're absolutely right. ADR has expanded greatly, particularly when we talk about things like access to justice. So I have a feeling we may visit with you again soon. But thank you so much for making time today to take us through the opinion. To everyone who's listening in, please do give a read to Opinion 518 and just to stay on top of our best practices as a third-party mediator, third-party neutral. Tim, thanks again.
Well, thank you.
Thank you for joining us on Resolutions. Today's episode has illuminated the powerful impact of effective dispute resolution and showcased the incredible individuals who dedicate themselves to this important work. Our mission is to explore the diverse world of dispute resolution, and we hope we've inspired you to engage with conflict and collaboration in new ways. If you're not yet a member of the ABA section of dispute resolution, we invite you to join our community of professionals making a difference. Your involvement can help us build a more harmonious society together. And if you found value in our conversations, please consider leaving us a review and a 5-star rating wherever you listen to podcasts. Your feedback helps us reach more people and continue our journey towards excellence in dispute resolution. Until next time, keep solving problems, building bridges, and creating positive changes in your communities.